So once again, welcome everyone to the Supreme Court and the environment. Where are we and what's ahead? I'm Pat Almanrode and I'm co-facilitator of Third Act Lawyers. We're a working group of Third Act, a national advocacy organization mobilizing Americans over 60 to protect and restore both our damaged climate and our fragile democracy. There are currently about 50,000 Third Actors all over the country, and we're growing every day. There's probably a local affiliate near you if you're not already involved with one. There are also several nationwide affinity-based working groups within Third Act, like Third Act Educators, Third Act Faith, Third Act Creatives, and your host for tonight, Third Act Lawyers. You can find out more at thirdact.org, and we hope you'll consider joining us if you're not a part of Third Act already. Tonight's webinar is co-sponsored by 350 NYC and the Green Education and Legal Fund. And so check them out too. Our presenter tonight, Sam Sankar, is Senior Vice President for Programs at Earthjustice. Earthjustice, as so many of you know, I'm sure, is the premier nonprofit public interest environmental law organization wielding the power of law and the strength of partnership to protect people's health, to preserve magnificent places and wildlife, to advance clean energy, and to combat climate change. Sam leads the organization's program leadership team, which develops Earthjustice's strategy for carrying out its mission through litigation, lobbying, and regulatory advocacy and communications. Sam has been working on environmental issues throughout his career, which has included service as a line attorney at the Department of Justice, Environmental and Natural Resources Division, as a senior executive at General Electric, and as deputy chief counsel of a presidential commission formed to investigate the 2010 Deepwater Horizon oil spill. He's also worked as a boat captain, a machinist, and a senior advisor to the Nature Conservancy. Sam received his BS in civil engineering from Cornell, an MS in environmental engineering from Stanford, and his law degree from the University of California, Berkeley. After law school, he clerked for Judge William Fletcher of the Ninth Circuit, Judge Lewis Pollack of the Eastern District of Pennsylvania, and Justice Sandra Day O'Connor of the U.S. Supreme Court. He's been widely published, including in the New York Times. Sam lives in Washington, D.C. with his wife and 2 kids. Please type your questions in the chat as we go, and we'll get to as many as we can after Sam's presentation. So let me, with all of that, turn on Sam's mic and hand it over to him.
Hi, everybody. Thanks, Pat, for the introduction of somebody who seems, I guess that's me. It never quite sounds he could be happy you describe all of that. And I wanted to thank Third Act for having me here tonight, and for all of you for taking such an interest in environmental issues and with the ones that affect us all. So I'm going to quickly go through some of this introductory material because Pat really covered so much of it very well. Today, we're going to talk a little bit about very quickly about what Earthjustice is. And then the main focus that we're going to talk about today is what's going on in the Supreme Court and the courts more generally, and what this means for administrative law, which is the bulk of the law that is actually that relates to environmental law. And what does it mean for climate and for administrative law and federal regulation more generally? And then what can you do? And I will preview what can you do is going to have less to do with the Supreme Court stuff and more to do with the things that we can do that don't have anything to do with the Supreme Court, because that's where we make a lot more change effectively. I'm going to do my best to keep an eye on the chat. I love answering questions. And honestly, when Pat said, can you talk for half an hour? I said, nobody at Earthjustice ever lets me talk for more than 3 minutes. So I'm not really used to it. I have a bunch of things I can talk about. I also love to answer questions along the way, and hopefully we can leave some time for that at the end as well. So with no further ado, here we go. So Pat already introduced me. I was an engineer. I clerked a bunch. I worked in private practice and the Justice Department and at a large corporation. And all that stuff makes me somewhat unusual for a nonprofit lawyer. Many of the environmental lawyers in the nonprofit world have been nonprofit lawyers their whole lives. So I'd like to think I bring a little something different to Earthjustice in that regard. I have 2 kids. I have a dog. I don't know where she is. Oh, there she is. She's right over there. And I'm a woodworker. That's one thing that Pat didn't mention. So I'm sure there are some woodworkers out there. I'm a fairly avid amateur, I guess I would say. So, but enough about me. Earthjustice, right? First of all, Earthjustice, there's a lot of us. This is a picture from last October. We now have 550 staff in 15 offices nationwide. That includes 200 lawyers. And those 200 lawyers are handling a huge range of matters. There's 1,100 open matters here. Somewhere around 400 of them are active. Those of you who are lawyers know that you can have a lot of cases sitting in the files that are technically open, but they may not be going anywhere. We've got about 400 that are moving. We also do a fair amount of lobbying. What you might find interesting is this chart at the bottom that talks about where we're getting our work done. And I think once upon a time, this forum mix would have been almost entirely federal courts. And now, as you can see, it's got a lot of other stuff going on, in particular, state utility commissions and state administrative tribunals. That's preview of coming attractions, what I'm going to talk about at the end. I have the presenter view up here. So I'm going to get this out of, this happens occasionally where, let me get this straightened out. Unfortunately, the typical solution to this, when this happens, is to zoom in and do it out of presenter view, which I'm afraid is makes it look like I don't know what I'm doing. But this is the best solution that I've found. All right, so I'm gonna try sharing again, and there we go. Let's try this. Perhaps not as elegant, but Pat, does that look better now?
Yes, it does. Thanks, Sam.
There you go. Thank you. Okay, well, let me get myself reoriented here. So there's a lot of us. Like I said, maybe you haven't seen this slide yet. But there you go. There's 550 of us. Handle a lot of matters. Did you see this slide yet, Pat? Nobody had any idea what I was talking about at this moment.
We saw it, but we can see it better now.
You see it better now. Okay. So again, the main thing here is to look at the forum mix. Again, less than half of our cases happen in federal court, although of course those are very important cases because our federal laws, our federal environmental laws, most of which were passed around 50 years ago, remain the bedrock of environmental law for the country. This is going to be a little tricky to move through. Okay, so all those folks, all those cases, who are they on behalf of? Well, over 1,000 different clients. Again, once upon a time, 20, 30 years ago, we represented almost exclusively national environmental groups. And that's changed a lot as well, because we've recognized that in order to get effective advocacy, we need to be working very directly with groups that are on the ground. State and regional groups, community-based groups, Indian tribes, the organizations that have boots on the ground and local advocacy are the ones that are the most effective clients and partners. We don't even call them clients anymore. They're partners, because in many cases, we're not even actually litigating. We're able to resolve things before we get to litigation or relatively soon after we're filing a lawsuit. And that means that a lot of these groups aren't even directly focused exclusively on the environment. In particular, civil rights and public health, labor groups, they are becoming important clients and partners as we've seen the environmental movement expand, because more and more people are recognizing that climate and other environmental issues are important. And in terms of geographically, like I said, 15 offices. Those of you in New York will be pleased to see that we have a bunch of action happening there. We opened a Midwest office. I heard from Pat that there were a bunch of people in Chicago. We have an office that we opened up 3 years ago in Chicago to cover issues in the Midwest region, and that one's bulking up as well. We also do a lot of work in Puerto Rico, and that didn't show up on the map, and a fair amount of international work as well. Okay, so enough with the introductions. You wanted to hear about the Supreme Court. So this is the Supreme Court that I knew in 2003 when I walked in the door and I started working as a law clerk there. And I actually kind of sepia toned this picture because this is what the picture that I have on my wall now looks like. It's all faded. And so is my memory of this court, because this is a court that we thought of as a center-right court, center-right wing, 5 solid conservatives by any measurement, but only one of them is left. And that one is a bellwether for what we've got now. So now what we have is this, a very different court. Justice Thomas, probably not even on the fringe of the right of this court at this point. Staunch conservatives in 6 of the seats, and liberals in 3. So we'll talk a little bit about what a staunch conservative means these days, and because it's sort of the notions of what a conservative judge is have changed quite a lot over time, and we're seeing that very much play out. We'll talk a little bit about why. So it isn't just, though, the Supreme Court that's changed. Donald Trump was able to appoint an unusually large number of judges to the federal bench given the time that he was in office. As you can see, nearly as many Court of Appeals judges as Barack Obama did. Many people criticized President Obama for not adequately prioritizing the judiciary, and well, whether he had a lot going on, I'm sure, but this was definitely the result, that the judiciary is different now than it was before. I give credit to the Biden administration. They have seen the light on judicial appointments and have been pushing much more aggressively. But as you know, the Senate has been a complex institution for the last several years, and that's made it difficult. But Joe Biden's making some real progress on that. So that's the judicial landscape. Conservative courts and a Supreme Court that's swung even more conservative than the appellate bench and the district court bench in general because of the unfortunate timing of some of those departures. So we're going to talk about a couple of cases where the Supreme Court has interpreted environmental laws in, I'll be neutral about it, in interesting ways. And we'll talk a little bit about what it's doing in those cases and why. And in each of these cases, what you're going to see is a kind of a narrow, arcane issue that's being, that the court is doing, and in a way that it's very hard to get newspaper headlines on this stuff because it's kind of technical and under the radar, and yet it's super important, not just in the immediate cases, but in the way the Supreme Court is approaching the very premise of federal regulation and environmental law in particular. So West Virginia versus EPA. Let's see. Okay, so yikes, right? This is the procedural history of West Virginia versus EPA. There's a million color-coded things going on here about regulations and all kinds of stuff. Here's what the case is about. I'm actually going to go off sharing for a moment here just to explain it. There's a statute called the Clean Air Act. You might have heard of it. And the Clean Air Act allows EPA to regulate different kinds of sources. And it has some arcane rules for how the regulations have to be developed. And in particular, after the Supreme Court decided the Massachusetts versus EPA decision, in which it said carbon dioxide was a pollutant, a gas that EPA had to regulate under the Clean Air Act, the Obama administration EPA decided it would start developing those regulations. In order to do it, it had to go through this somewhat arcane process where it developed what's called a best system of emissions reduction. So what EPA was going after was trying to develop regulations for carbon dioxide emissions from power plants. So with that, I'm going to go back to the chart here. We're going to go back to sharing that. Okay, so what you need to know is that the Obama administration put in some regulations. They got challenged. The Trump administration tried to do something again, or to pull them back, and it went back and forth and back and forth. But the net result was that 2 years ago, the Supreme Court ended up reviewing the Obama administration rule, even though that rule was not enforced, and the Biden administration had said it never would enforce the rule. So for those of you who follow the Supreme Court, or really federal courts in general, you know that this is like a blatant standing problem, right? You don't take this kind of case. And yet the court seemed hell-bent on taking this case and on opining on the meaning of a rule and interpreting a statute that really wasn't an issue and it wasn't going to apply to anybody. That was Section 111. Section 111 of the Clean Air Act is for new sources of air pollution. So when you build a new emitter, a new power plant, a new whatever, this is the section that determines the emissions. So like I said, you determine the standard by figuring out what can be achieved by the best system of emission reduction. I try not to get into technical details on these things, but this one's interesting. So the way the Clean Air Act works on this is not that it doesn't tell EPA to go instruct everybody to install a certain kind of pollution control on their power plant. What it says is, EPA, go figure out what the best technology, best approach is, considering cost, that power plants could use to reduce, in this case, their carbon dioxide emissions. Then figure out the standard based on that. So if people go out and figure out, find the best way to do it, and then tell people they have to achieve that numerical reduction. And then let people do it however they want. So that allows industries to find more efficient ways of getting there if they can. So rather than specifying a technology, you specify a reduction. So that word system becomes really important. Now, the Obama administration had said, look, reducing carbon dioxide emissions from power plants, the most effective way to do it is actually to switch generation, to shut off the coal generation turbine and install solar power plants or solar panels instead, or simply to just start buying the power from a clean energy provider. The best system is a managed transition away from fossil generation. Well, the Trump administration disagreed, and the Trump administration said system can only mean something that you install on the turbine itself, on the generation unit itself. And so this is the issue that the Supreme Court was dealing with. What does system mean? And the Biden administration said, well, look, we're not even trying to enforce this rule, but if you force us to explain what's going on here, we say system has a broad meaning. And in fact, EPA has delegated authority to implement this Clean Air Act. And because of the way this statute works, and because EPA isn't requiring anybody to do anything, what they're saying is you could achieve this through switching your generation. You can go ahead and do it however you want, but we know you could get to this level. We're not requiring you to switch emissions or switch generation. We're just telling you that this is what you could achieve. So this made it to the Supreme Court. And the Supreme Court said no. Essentially, it said system really only means what the Trump administration said. It can only mean things that you install inside the facility on the generation unit yourself. Well, why? This word system. How do traditionally agencies get a lot of latitude in interpreting a kind of open-ended word like system. System, how do you, it can mean a lot of things, and the agency usually gets a fair amount of latitude in figuring that out. Well, this is where the Supreme Court announces a new doctrine. And when the court announces new doctrines, it's a big deal. And this one, they called the major questions doctrine. And they claimed that they had been doing it before, but anybody who watches carefully knows they weren't. So the major questions doctrine is this: when agencies interpret laws in ways that implicate matters of, quote, vast economic and political significance, the court now says they have to point to clear congressional authorization for the powers that they claim. Among other factors to decide whether it's vast economic and political significance, is it new? Is it disputed? Are people concerned about it? Are people paying attention to it? So how do you know if the major questions doctrine gets triggered? You really don't. You just have to sort of wait until the Supreme Court tells you. And then kind of amazingly, what the Supreme Court seems to be telling you is if people are paying a lot of attention or the issue is in public dispute, well, then we interpret the laws more narrowly. Of course, that's very much at odds with the traditional conservative principle of taking the words of the laws literally. That's what Justice Thomas would have said. That's the way you read laws, literal textualism. Here, it's something quite different. It's saying, if we feel like there's a lot of potential for political dispute, or if this seems to be a new thing, or, well, maybe we're going to, or economic, if it's going to cost people a lot of money, then we're going to narrow it. And of course, they don't think about it in the other direction if it has, say, vast impacts on people. They're just thinking about it from the industry point of view, the economic point of view. All right, so that's the major questions doctrine coming out of West Virginia versus EPA. Where does this doctrine have its roots? It has its roots in this thing called the non-delegation doctrine. Now, when I started out as an attorney at the Justice Department, it was a long time ago, 20 years ago, about 20 years ago. I got assigned a bunch of cases. I was an appellate lawyer, and they gave me a stack of cases that they said were unlosable. They said, you can't screw this up, kid. You're going to jog around and argue in lots of circuits about this. The issue was the Health Insurance Portability and Accountability Act. Everybody knows HIPAA, those HIPAA disclosures you had to do. All of the medical associations were challenging these regulations as violations of the non-delegation doctrine. And my supervisor at the Justice Department said, you can't lose. The non-delegation doctrine has been gone since the 1930s. The Supreme Court said there's nothing to it. It's gone. So I just, I like smacked them down everywhere. I'd go around Third Circuit, I won. Second Circuit, I won. It was great fun. I couldn't lose. Well, guess what? The non-delegation doctrine is back. The Supreme Court thinks that the non-delegation doctrine is real. And the idea of the doctrine is that Congress isn't allowed to give away any of its power. So Congress can't, for example, say, rather than legislating ourselves and taking the time to specify the complicated details of the statute, we're going to we're going to create an agency, give ourselves supervisory powers, and let that agency go do that work rather than hiring all those people ourselves. So regardless of what you think of the wisdom of that doctrine in the abstract, it has no historical justification. One of my close friends, Julian Mortensen, is a scholar, and he's written articles in the Atlantic. He's a real historical scholar, and he went through and he dug around in all of the textualist and originalist sources and showed that actually the early Congresses were busy delegating power left and right. These folks were in Philadelphia, and they could not be bothered to figure out all the business of a new nation. They were just creating agencies all over the place and saying, you figure it out. We'll give you the power. You go do it. President, you appoint somebody to run that thing, and if we don't like them, we won't confirm them. Or we won't fund them. Or we'll write a law that overrules whatever they do. That was the conception of the framers. So this non-delegation doctrine, which underlies this major question doctrine, is a fib. It's kind of made up, but it's convenient. We'll talk about more why it's convenient. All right, so that was West Virginia versus EPA. Clean Air Act case, striking down a rule about carbon dioxide emissions at power plants using the major questions doctrine, which is rooted in this non-delegation doctrine. Keep that in your heads. I know it's not easy. Next case, Sackett versus EPA. Sackett versus EPA was last year. It made more headlines because it was a Clean Water Act case. And if you do polling, you realize that clean water is much more salient issue to most people than climate. I know it's hard to believe, but that is true. So Sackett versus EPA involved this lake, Priest Lake. Unlike that case that we just talked about, West Virginia versus EPA, this case is about real stuff, real people, very easy to picture. So that little community you see in front is where the Sacketts lived. And Priest Lake in front of that is in Idaho. It is a pristine lake in great shape. Lots of people have properties along that, and they like the way it is right. They like the way it stands right now. That lake is protected by the Clean Water Act. And the Clean Water Act says that the various agencies in the government, essentially the Army Corps of Engineers and EPA, are allowed to prevent the disposal of pollutants, including dredge and fill material, into the navigable waters. The navigable waters. Now, if you heard navigable waters, you might say, well, okay, figure out what you can, paddle your canoe in. But of course, strangely, the Clean Water Act then defines the term navigable waters as the waters of the United States. So that seems quite broad. Well, what exactly does that mean? This law is now over 50 years old. Well, early on in 1975, well, first of all, when the law was first passed, the Army Corps said wetlands were not covered because it was just navigable waters. That's the way they read it. There was a hue and a cry all over the country. People said, this is crazy. You can't protect the waters if you don't protect the wetlands that are adjacent to them. If you're pouring pollution into the wetlands, it goes straight into the water. That's nuts. So in 1975, the Army Corps reversed course and said, wetlands are covered. We've changed our mind. Wetlands are covered. 1977, Congress amends the law in a way that seems to most of us to suggest that it agreed that wetlands were covered. 1985, Riverside Bayview, the Supreme Court says that reading, and I'm missing a couple words here, was correct. 1985, Riverside Bayview says wetlands are covered. In 2006, though, 21 years later, we get a fractured decision in a case called Rapanos versus United States. So this is almost 20 years ago. In Rapanos versus United States, the liberals on the court, there were 4 of them then, said, wait, I don't know why we're still arguing about this. 1985, Riverside Bayview, right? This issue is decided. But 4 of the conservatives said, actually, we've got a bone to pick with this. We think that navigable term, even though it's defined by a broader term, really does work here, and it's only relatively permanent waters with a continuous surface connection. And that means wetlands aren't covered unless they're just indistinguishable from the waters. Memorably, they said, if you wade out of the water, the only wetlands that are covered are the ones where grass starts coming up and then you're on the land, and there's no easy way to say when the water ended and where the wetlands began. Justice Kennedy, very characteristically for Justice Kennedy, said, well, he wrung his hands and he said, I'm not sure. I want to write my own test, which he loved to do. Now, I work for a justice who also liked to do that, so I can't throw so many stones. And Justice Kennedy said there has to be a significant nexus, and the wetland has to move my thing here significantly affect the integrity of the navigable waterway. So he was saying there has to be some connection, but as long as there's some scientific connection, you're in. These wetlands are covered. But clearly, again, those four conservatives, this was not something they wanted. They had been arguing about this for some time. So, but Rapanos versus United States, when you have a decision like this, the deciding vote, the fifth vote, in this case, Justice Kennedy, that opinion governs. So for years, for almost 20 years, we've been operating under Justice Kennedy's formulation, which, by the way, isn't crazy. It sort of says we cover wetlands when they're scientifically kind of, directly connected with the surface waters nearby. And that was the regime under which the Sackett case came up. So the Sacketts lived near Priest Lake. You can see the little caption down there. That's Priest Lake. There is a wetland on the other side, Kalispell Bay Fen, and that area in between is the Sacketts' bit of property. You can see there are some houses there, and you can see there are some houses between the Sacketts' lot and Priest Lake. In fact, I'm going to give you some even better pictures here. So that was that same picture above. You can see the pink arrow there. The view from the pink arrow is that little pink bordered picture, pretty clearly a wetland. The view towards Priest Lake, the green arrow, well, you can see the lake pretty clearly from right where it is. And the blue arrow shows what the Sackett wetland looked like when their neighbors called EPA and said, these guys are filling in the wetland on their property. We don't think they can do that. So the neighbors ratted out the Sacketts. EPA came in and asked the drivers of the bulldozers, hey, did you get a permit to do this? And they said, no, we work for the Sacketts. In fact, they own an excavation company. Now, why does it matter that the Sacketts own an excavation company? Because excavation companies know full well that filling in wetlands is something that you need a permit for. The Sacketts had decided to try to get away with it, and they didn't. But they became a bit of a cause célèbre for the conservative movement, and they managed to get their case to the Supreme Court and to ask the Supreme Court whether their land was covered. Well, here was Sackett versus EPA. We had 5 justices who said the Rapanos plurality was correct, and the clean water only covers relatively permanent water bodies, and only those wetlands that are indistinguishably part of a covered water body. What was a little terrifying is that several of these justices, 2 of these justices, actually said it has to be literally navigable. You have to be able to get a boat to actually be able to navigate and move commerce along this waterway. Otherwise, it's not covered. So the stream that goes into the bigger river is not covered. And a whole lot of tributaries, where especially ephemeral ones that only come when it's raining heavily, and all of us everybody who lives in the West knows that huge portions of Western water come through ephemeral streams. Those are definitely not covered under the formulation of the far right justices, as well as probably under the justices in the middle. What's interesting is that Justice Kavanaugh was not having any of this. Justice Kavanaugh said, I don't know, I read the law and the statute and this word adjacent and other words in this statute to say, absolutely, these things can be covered. And it's up to EPA to figure out how specifically to administer that. But this relatively permanent water bodies, indistinguishably part of, I'm not really interested in that. How did they get there? How did these 5 justices manage to part way, even with Justice Kavanaugh? Well, they used this exceedingly clear statement rule. So we talked about the major questions doctrine. Now we've got an exceedingly clear statement rule that showed up. And they said Congress has to use exceedingly clear language if it wants to significantly alter the balance between federal and state power and the power of the federal government over private property. And then a little later, they slip in the note that regulation of land and water use lies at the core of state authority. So what are they saying? They're saying if the federal government wants to regulate land and water use, it's significantly altering the balance of power, and Congress has to use exceedingly clear language to do that. Even if it was doing it 50 years ago, in a statute that was passed by huge majorities of Congress over President Nixon's veto. So these were laws that were passed in a bipartisan way with broad sweeping language. And one of the things, if you work with the Clean Water Act, you realize is the law is written in this incredibly expansive way. It says our goal is zero discharge by 1985 of pollution to waterways. Our goal is to restore the chemical, physical, and biological integrity of all waterways in the country. And they granted pretty sweeping authority to EPA to do that. But they also carved out some important sources, agriculture in particular. So it wasn't like Congress was going crazy. Congress carved out some areas, but then said, EPA, go get the job done with a comprehensive regulatory regime. So apparently the Supreme Court didn't love that. So that was the exceedingly clear statement rule. There was also, they went a little further even. Two of the justices, Justice Gorsuch and Justice Thomas, said, you know, we're not just worried about the way EPA has interpreted Congress's law. We're worried about Congress's law to begin with. Where does Congress get off regulating waters that aren't actually navigable? And they said the court's Commerce Clause jurisprudence has significantly departed from the original meaning. Federal environmental law is the biggest area of such a mistake. So they've got it out for environmental law. And they talk about the clean water. They criticize EPA and the federal government for using a, quote, New Deal conception of Congress's commerce power. So remember, Congress's commerce power is the foundation for a huge number of laws, notably the 1964 Civil Rights Act, which says that you can require the instruments of commerce to actually obey federal law, because commerce is fairly widely construed. In Wickard versus Filburn, the Supreme Court said even growing a single grain of wheat in your backyard is inextricably intertwined with interstate commerce. So Justice Thomas and Justice Gorsuch, they're ready to pull the plug on that. They want to go back to pre-New Deal understanding of the federal government, a much, much more limited authority in Congress, much more limited regulatory authority in Congress. Interestingly, this poll came out, I think, right before the decision. No, maybe after the decision came out. This was a term that included, no, it didn't include Dobbs. They had done the analysis. This is a New York Times graph. They'd done the analysis of recent disputed decisions from the Supreme Court. And there was no decision in which the Supreme Court was more out of line with public opinion than in Sackett versus EPA. And so that's astonishing to me, right? Like I said at the beginning of this, clean water polls really well. People care about clean water. They understand the connection between wetlands and clean water. And they even 2/3 of Republicans, traditionally sort of opposed to federal regulation, believe the Clean Water Act should cover it. And yet the Supreme Court, no, a majority says the other way around. Okay, passed. Clean Water Act, Clean Air Act, Sackett versus EPA, and West Virginia versus EPA. So what's coming up? This year, it's a case called Loper-Veit versus Raimondo. There are a couple of other cases that we're watching pretty closely, but Earthjustice just filed an amicus brief in Loper-Veit versus Raimondo. Let me see. I don't think I have great. Oh no, we'll get there in a second. I'm gonna stop sharing a bit because I don't have great slides on this yet because this case hasn't happened. Loper-Veit involves a National Marine Fisheries Act regulation that required fishermen in the Northeast to pay for the cost of having observers on their boats. And that initially strikes you as surprising. The statute says that fishermen can be required to carry observers on their boats. But if you look at the history of the statute and the way it's been implemented, especially with foreign vessels, there's a pretty strong argument for saying that it is absolutely legitimate to have fishermen pay for observers on their own vessels. And the way the courts had interpreted this is they had said, like, look, this is kind of a squishy issue. We think it could go either way. And in a situation where the statute could be interpreted in multiple ways, we rely on this thing called the Chevron doctrine. The Chevron doctrine says that when the agency is interpreting a statute, the court should first look to see whether the statutory language is ambiguous. That means if it was amenable to multiple interpretations, and if the language could be interpreted in multiple different ways, the tie goes to the agency. The agency is the one charged with administering the statute. The agency is under the control of a political appointee and by the president. The agency is subject to the control of Congress. So we're going to let the agency figure this one out in light of the way that the regulatory system is going to work. So I'm going to start sharing this so the Chevron doctrine is the way these lower courts decided it. And the Supreme Court took Loper Bright and just recently another very similar case in order not to decide the issue about whether or not fishermen can be asked to carry to pay for observers, but rather to examine only whether the Chevron doctrine applies, whether the Chevron doctrine exists. So here's the irony. I love this. The Chevron doctrine was created in a case called Chevron versus NRDC. Who won Chevron versus NRDC? Chevron did. Chevron won Chevron versus NRDC because in that case, the Reagan era EPA had issued this interesting regulation under the Clean Air Act. Industries said, look, if we're in the situation on the left, if we have to reduce pollution, we would rather be able to aggregate all the sources that we have together and reduce the overall pollution, even if individual pollution from one of those sources goes up, called bubbling. So the idea is rather than have to reduce everything that you've got, you just take your aggregate emissions down, and it doesn't matter whether some of them go up or some down. This was called bubbling again. Chevron wanted to do this. NRDC, a frequent client of Earthjustice's, did not. Chevron won. Because at that point, the industry said, we absolutely want the agency to have some discretion to interpret this law sensibly. It's cheaper and more sensible to do it this way. Bubbling makes sense. And NRDC said no, and NRDC lost. So this was a doctrine created by a right-wing court, right-ish wing court, to uphold a Reagan-era regulation that allowed industry, that gave industry what it wanted. And now we're tearing this doctrine down, tearing it out from the roots as this unholy creation of the administrative state. So yet again, we're seeing the Supreme Court. I mean, everybody's predicting they're going to get rid of the Chevron doctrine. And I think that it is a case that because it's around about fisheries and herring is probably not going to grab national headlines the way maybe even that Sackett case did. But this is, as Pat and I were discussing before, this is the sleeper case of the term, because this is a case in which the Supreme Court is cementing this idea that administrative agencies have no business taking any kind of, have no business being the folks who have sensible interpretations of these laws, that it's really the court's business and only the court's business to read these laws. So what's going on here? Number one, we see pervasive distrust of the administrative state. These 5, 6 justices, everywhere you look in these opinions, they are, and everywhere we see in the political rhetoric, there's this denigration of the, quote, unelected expert. And I always laugh because I say, okay, these unelected experts, what do they know, right? But what do you know, justices? Any of you ever been on a fishing boat? Any of you a scientist? Ever done any economics? You're all a bunch of law school professors from the Federalist Society that managed to get yourselves on the bench. What do you know? And we know, of course, that a lot of these issues are super complicated. And that is why Congress said, go figure this out, agencies. And P.S., if you get it wrong, the voters will throw you out or we will do a law. I mean, but nevertheless, the court really doesn't like it. It also doesn't trust past Congresses. In my view, this is a real society, like actual dislike of some of these environmental laws, and the idea, as you saw in the Sackett case and the reading of the Commerce Clause, it's basically like the court saying, we think it just went too far. We don't think these statutes are such a good idea. And so wherever we can, we're going to start chipping away at these statutes. So it's not just the administrative state, it's also Congress. We don't want to let Congress give agencies this power because the court knows that if you can't, because Congress can't regulate on all these at this granular level. So if you take away the power to delegate from agencies and then you read their statutes narrowly, everybody's losing their ability to do it. The last thing, this willingness to revisit precedent. It's ironic that in West Virginia versus EPA, the court said, look, if something's novel, we're going to look at it more closely. And then in Sackett, where they had a settled interpretation for 40 or 50 years, they said, well, we're going to get rid of the old interpretation. even though it's solid. They are absolutely willing to revisit their own precedents. That's what they care about, or that's what they're willing to do. Dobbs, of course, the abortion rights decision is the most glaring example of that, but we're seeing it all over the place. Old law, you just never know when you're going in front of the Supreme Court these days. Anything could happen. So where did all these justices come from? What's the story behind this? And why are they so hostile to this stuff? Well, in a candid little bit of an interview, Senate Minority Leader now, Mitch McConnell said, look, we got them all from the farm team, the Federalist Society. President Trump just knew what to do. He just did what he was told, which is put these Federalist Society judges on the bench. And that Federalist Society group, if you want to read an interesting book about judging, go read this recent book by Sheldon Whitehouse and my friend Jen Muller, talking about how major corporations, particularly the oil industry and the Koch brothers, were able to create and support the Federalist Society and the rise of these right-wing philosophies, because these right-wing philosophies are purely deregulatory. The only through line on a lot of the judging that's going on right now is that it benefits major corporations and pulls back on the ability of the federal government to regulate. All right, that's the doom and gloom. But as the slide says here, we will never rest at Earthjustice. So what can you do? Well, don't go to the Supreme Court. I had a justice not that long ago tell me in confidence, don't you ever come back here. We never want to see you again, because nothing good is going to happen if you show up here with one of your cases. Stay away. So where do you go? Well, remember that slide I showed you about all the different forums in which you can advocate? A lot of them are really important. So if you, anywhere you live and work, I guarantee you there's a utility commission, and there are decisions being made about clean energy infrastructure all around you. Clean energy infrastructure in terms of like installing renewable panels and wind turbines, but also electrification mandates. If we're going to solve the climate crisis, one of the most granular things that has to happen across the country is states, municipalities, localities are going to have to get homes and cars off of fossil fuels. This plays out in city councils. It plays out even in school boards all over the place. Insist on electrification. Insist on making sure that your local officials are pushing for new construction in way that is climate compatible. And this stuff is, anybody can do it. And here's the bad news, right? The other side's pushing in the other direction. If anybody's been paying attention to the news, you're seeing these solar bans, all kinds of disinformation that's being peddled by opponents of clean energy to get people to think that clean energy is a bad idea and that they should ban it. So fight the disinformation stuff. This is something, it is retirees on the other side that have the time to go to all these meetings and that are raising hell and slowing down the energy transition. Get out there, find these people, and stand up right after them and say, that's a bunch of hooey. Nobody's ever been hurt by a solar panel. Here's the real science here. This is what's going on. I did this just recently in Washington, D.C. A classic example is the local gas utility, wants to invest about $10 million in new gas lines. And a bunch of my neighbors said, do you know anything about this? I said, do you think we should be investing in gas lines right now, adding gas transmission capacity? The reason they want to do that is this is the last gasp of the fossil fuel industry. And the more infrastructure they lay in, the longer they lock in lower pricing on fossil fuels, and the longer they perpetuate this industry. So third act, folks, your job is not to go to the Supreme Court. Your job is to go everywhere else. Everywhere else. State, local governments, these are the places to make change these days. Pay attention to the way electrification is playing out and the way your local utility is generating electricity and distributing it. And with that, I will close it up.
Well, Sam, thank you so much. That was fascinating. A little too quick, actually, to take it all in, but we've got it recorded, so we can revisit it time and again. There are a couple of questions that have come up in the chat, but let me just pull the moderator's privilege, I guess, and ask you point blank, how do you handicap Loper Bright? What do you think's going to happen?
Oh, it's going down. There's no question about it.
Really?
Oh yeah, the court is super hostile to Chevron. Even the centrists on the current court have. But here's the good news, right? nobody wins or loses cases based on Chevron, right? The Chevron principle is a bunch of mechanics around the basic idea that when judges aren't 100% sure what to do with a statute, they ought to put an ear out to the agency, because the agency is the long-term player on the law. The agency is the one that's going to be dealing with this over and over and over again, and the agency is under political control. So I've won plenty of cases without talking about Chevron that involve that principle about how to interpret a law. Here's another secret. A lot of environmentalists hate Chevron. Remember, NRDC hated it. They lost that case. The Chevron doctrine was created to defeat NRDC, and interestingly, they put out a tweet not too long ago saying, we lost the case and we want to keep it. So many enviros, especially the ones who work with agencies like the Forest Service and the Bureau of Land Management, don't like Chevron because it gives those agencies, which traditionally have been captured by industry, gives those agencies more latitude to interpret laws in ways favorable to industry. The reason why Chevron keeps coming up, why the industries don't like it, mostly is because EPA is one of the few agencies out there that isn't terribly industry captured, and EPA still tries to do things aggressively. So if you care about it, all the EPA public health lawyers have always loved Chevron. All the endangered species, public lands, waters lawyers hate Chevron. So it's not actually clear, in the abstract, whether you want it or not. The problem here is that when a court is saying, look, we're gonna take more power for itself, I guess it matters what court it is. And right now it's not the court we want to be taking more power for itself. Right. Does that make sense, Pat?
Yeah, it does to me. Yeah, thank you. We have a question that's a little bit out of left field, but it's something that comes up a lot in environmental circles. I'm sure you've heard it before. One of our participants asked, should trees have standing? The whole rights of nature thing. So
it's a great question.
Has that question come up to the Supreme Court, or is there a case coming in this term that might raise it?
So this allows me to talk a little bit about Earthjustice for a moment. The first Earthjustice case was a case called Sierra Club versus Morton. And anybody here who studies environment, that's the first case you learn about environmental law, and it's a standing case. And it says that you got to have people with actual stake in the matter that are your plaintiffs. And there's a memorable dissent by Justice Douglas. He says, like, look, I think trees should have standing, essentially, and that should trees have standing was an article, a law review article. That phrase comes from that thing. So here's what I'll say: you cannot win movements. You can't drive political movements, and you can't get change without people who believe and support that change. So you can't protect the tree. The trees can protect them. Well, I should say the trees can be plaintiffs, but they can't protect themselves. If you don't build a meaningful constituency around an issue, a group of people who care about it, your short-term prospects may be good, but your long-term prospects are going to be terrible. So I actually consider it a hidden blessing that those early cases came out the way they did, because they forced organizations like ours to go looking for clients, and now to have clients coming to us, having a real stake with people on the ground. That's the reason why we work with community groups, because litigation can only do so much. You need to build political and movement power on the ground. And cases like Sierra Club versus Morton that forced environmental litigants or environmental litigators to go work directly with impacted individuals change the movement, and we wouldn't have, for example, the environmental justice movement were it not for that. So should trees have standing? I don't know. They're not going to have standing anytime soon. In fact, if anything, the court is cutting back and being more restrictive in the kinds of people who have standing.
Well, yeah, they're just when they want to, they just ignore standing altogether.
As with that West Virginia versus EPA case, there's been a lot of it. They're pretty creative. Yeah,
that was a comment from somebody earlier too.
Yeah.
This is an interesting question from Howard. Can you comment on the public trust doctrine and the potential of constitutional litigation at the state level to create an environmental and climate quality more broadly?
So Pat, if you, I'm not going to try to do it here for fear of losing things, but if you Google Great Salt Lake and Earthjustice, you'll see some press release and information about a recent case we brought in Utah. arguing that the public trust doctrine in Utah requires this. Oh, so I should step back. The public trust doctrine is this idea that governments of any kind hold the land and waters and natural resources in trust for the residents. And that means that the state has a higher obligation to preserve those for the public benefit. So that means that even, for example, in Utah, a state that has Western water rights, the Western water law that works like most Western water laws, where if you start using water, you get to keep it forever. The public trust doctrine might supersede that at a constitutional level and say, look, if too many people have water rights and there's not enough water for the environment or for regular people who don't hold water rights, well, maybe we need to reevaluate these water rights to begin with, because there's a deeper concern, the concern of the government's requirement to maintain the public trust or to hold these resources in the public trust. So we have started to use some of these cases. No, not every state has a public trust doctrine. I want to say it's like a dozen states, I think, that have some form of that doctrine. Interestingly, Louisiana, I believe, is one of them. Hawaii is one where we've made a tremendous amount of progress in restoring waters that were damaged by the plantation economy and pulling the management of those waters back to restore ecosystems. So public trust doctrine is a very interesting thing, and I think we're going to see it exploited more. The reason we chose that Great Salt Lake case is because Great Salt Lake is drying up because of water, because of agricultural use of water. And the reason why it's getting some teeth, the issue has some teeth, is the lakes, as the lake recedes, it's exposing toxic sediments that are blowing all over the place and are actually causing real public health problems. So it's not just a left-wing enviro concern anymore. It's a very real public health concern. So our biodiversity defense team said, we see an advocacy opportunity here because this is the case that's going to grab headlines. It's going to get people to pay attention. Whether or not we win or lose, we will really be elevating the issue of Great Salt Lake and the mismanagement of the water and bringing that to public consciousness. Hopefully we can make some change.
Right. Thank you. I think I'd like to open it up to folks who'd like to ask a question verbally. If you'll raise your hand using the reaction button down at the bottom of your screen, that puts you up at the front of the queue and we can unmute you for your question. While we're waiting for folks to do that, let's see, Jane had a question. Will loss of Chevron deference create more activist judges even at the district court level? Gives them an opportunity, right? If that happens.
And again, what Chevron's doing is giving judges a chance, giving judges more opportunity to put their stamp on what the laws should say. So in these complex statutes like the Clean Air, I mean, the Clean Air Act is enormous. It's just gigantic statute. It's very technical. And if a judge wants to say, well, I'll figure it out and I'll tell you exactly what this means, well, that certainly puts more power in the hands of judges. It is interesting that when you see a lot of these conservative judges at the district court bench deal with statutes where they don't really have a dog in the hunt, they're quick to defer. They're like, I don't understand this. I defer. This is really complicated. I trust the agency. I'm staying out of this. It's on these environmental laws that they seem to know exactly what they're doing, and suddenly they acquire vast interpretive powers.
Wow. Oh, man. I don't see any hands raised, but we'll give it another minute or two.
Well, thank you to the folks who appreciated it. This is unfortunately, this is about as close as I get to litigation anymore. They don't let me go to court. It's mostly budget spreadsheets and fundraising presentations and things like that for me. So it's always fun to talk about the work that so many of our attorneys do.
Well, speaking for myself, at least, it was extremely fun to listen to. So just want to thank you again for that. Also want to thank our co-sponsors, 350 NYC and the Green Education and Legal Fund, and a special thanks to Third Act lawyer Seth Weisbord for getting the wheels in motion for this program. Just want to let everybody know we'll have an announcement soon for our November webinar, which will focus on the democracy side of our portfolio. We'll feature the Leadership Now Project, an organization of business and thought leaders taking action to protect and renew American democracy. and driving results by focusing on meaningful research and education, operational excellence, and member value. You won't want to miss that. Last, thanks to all of you for joining us tonight. Please note that we'll make a recording of tonight's session available soon, so watch for that. And if there are no other questions, thanks again to everybody. Sam, thank you especially, and good night.